we would never tell a client that. We would never tell a client not to appear at a court proceeding.
All rise. Thank you. Good afternoon. Please be seated.
Good afternoon. This is the State versus Leonardo Blundo, RCR 2023-124-588. Counsel, please state your name for the record.
Tom Pitaro on behalf of Ms. Blundo.
Robert Glennen for the state.
Paola Armeni, Your Honor, on behalf of Leo Blundo.
Okay. Mr. Pitaro, do you happen to have video capability?
We are, I can see you, Your Honor. Let me see, hold on, Tom. Let me see if this will work.
Perfect.
There we
Thank
go.
you.
Oh, okay.
Thank you. And this was called under the case number of Mr. Leonardo Francisco Blundo's criminal case. Today's hearing is related to that. It's more of the court essentially versus Miss Melissa Blundo, question of contempt. My understanding is that we had a jury trial scheduled November 8th. Miss Blundo, according to a return subpoena and then a subsequent affidavit by the person serving the subpoena clarifying service as opposed to attempted service, served her at a restaurant in Pahrump late October. I believe it was the 27th. Miss Blundo has, and this is all by representation from Miss Armeni, and in large part, most of it through Mr. Glennen, sworn information from him at a motion to continue, and in opposition to a motion to defense, is where this understanding is coming from, as well, frankly, as subsequent filings on a pending motion in the criminal case to dismiss for double jeopardy purposes. So anyway, my understanding is that there was that service requiring her to appear in this court on the 8th. The time on the subpoena was 8:30, the normal beginning time of the trial proceedings in general. That prior to that, Mr. Glennen had indicated at the last hearing that he'd been in contact with Mr. Pitaro and or Mr. Fumo, who'd been engaged by Ms. Blundo throughout this process. She's obviously not in favor of her husband being prosecuted. Mr. Glennen indicated that he had contact with either Mr. Pitaro or Mr. Fumo off and on a regular course throughout the prosecution of this case. After service of subpoena, frankly, my recollection is there might have been one or two communications, and at a minimum communications conveying offers and soliciting Ms. Fumo's response or information regarding Marcy's Law as to the potential offer in the days leading up to trial, specifically likely late the week before trial, which would have been late that first week of November. And then negotiations were apparently being attempted. They were not fruitful over the weekend. It appears that Mr. Glennen did not communicate that likely to either Mr. Pitaro or Mr. Fumo, and definitely not to Ms. Blundo. His representations at the hearing were that although he was not specifically ordered by counsel or requested by counsel not to talk to her, that he was respecting their position as attorneys, and frankly my understanding is well known and respected attorneys in the Las Vegas area. So he was in large part communicating through the attorneys, but he had not reached out to Ms. Blundo personally. Those negotiations clearly did not go through. In the motion for dismissal that was filed in the criminal case by Ms. Armeni for double jeopardy. There was a affidavit attached by Mr. Fumo. He's representing that he was expecting a call from Mr. Glennen the Friday before trial, that he did not get a call. Mr. Fumo's indication was that he learned from Mr. Pitaro that there was likely going to be some communication from Mr. Glennen. Nonetheless, there was no communication from Mr. Glennen the day before trial on the 7th. My recollection is that Mr. Fumo reached out to Mr. Glennen, phone call, left a message or two. Late in the afternoon, there was some text exchanges between Mr. Glennen and Mr. Fumo, something to be along the lines of, is your lady going to be there? Response, I'll let your lady know when she is due. There's no, I don't think there's any text after that. There was a purported phone call, I think, that followed up shortly after that at some point, where Mr. Fumo indicated that he'd not been able to get a hold of Ms. Blundo, potentially opining that she was on the road or otherwise unreachable. Mr. Glennen took that at face value, didn't act upon it in any way, shape, or form after that. Presumed that she might have been on the way, as all facts point to the idea that subpoenas were never canceled. So Ms. Blundo was due in court the next day despite any potential negotiations and lack of communication. At the motion to dismiss hearing, there was questions by the court, well, the motion to continue / dismiss hearing after we picked a jury. What else, if anything, did you do? This is not like it's a case in Pahrump or Southern Nevada where all the parties are. Marshall County's brought in court staff, 60 jurors or so were summoned, took time off work. Do you call the witness themselves? What has happened? Nothing had happened except for reliance on the subpoena. The court, in a second, trying to recite the relevant facts so the parties can fill in any blanks that I've missed and where I was headed with that. It's escaping me. In any event, I was thinking about the arguments that were coming up. When the court was asking about what measures or efforts were done to get Ms. Blundo here, my experience as a litigator in the past was to make sure witnesses, especially ones from the out of the area, had places to stay or transport or the like, and there was arguments over what was required to be done. The court reviewed the statutes at that time and made the ruling, and I'm still of the same opinion that the statutes required in civil cases for fees to be paid up front for a day's worth of, can't think of the technical term, but food expenses to be paid up front, likely some transportation or things like that, but that is in the civil world. It's silent as to the criminal, so the inference is it doesn't have to happen up front, it's all after the fact. Reimbursement, and I believe the statute actually used the terms reimbursement. So while the best practices definitely would have been to take pains up front to make sure that a witness has a facility to stay, transportation, verifying travel and the like. If it appears in criminal within the state of Nevada, not technically required. And we argued over that, and I did find that despite it being a good idea and good practices, the state was technically not required to do that. The other arguments were largely related to the court's ability to hear a continuance, whether it's for good cause or under the Hill Bustos line of cases after a case had started as opposed to immediately before. That was rejected, and frankly some of the subsequent research and case law cited in the pending motion indicate that that definitely can happen after a trial starts. The extreme example is a witness dying or other good cause, so to speak. In any event, that's a tangential issue for today's hearing. So with all of that having been laid out, that's essentially my understanding of the circumstances getting us here. I'm going to welcome some more information from the parties to decide whether or not there was a valid order, there was compliance or lack of compliance with it, and what should be done. The rules on contempt are mixed between Chapter 22 and Chapter 50 of the Nevada Revised Statutes, and the witness non-attendance in Chapter 50 refers back essentially to 22. I believe it says just shall be punished if the court so deems appropriate as contempt. And contempt back in 22, potential penalties are up to 25 days in jail and up to $500 in fines. There's somewhat of a question in my mind regarding potential costs that could be ordered. It's crystal clear they are orderable in civil cases. And I'm just going to front load the parties. I don't like hiding the ball in any way. At first blush, and again, I welcome information. It appears that there was an order, there was non-compliance, and the question over civil versus criminal contempt is one that is somewhat muddied by our statutes and our Supreme Court, but the civil contempt is when any punishment, so to speak, or remedy is remedial in nature as opposed to punitive. Incarceration clearly is punitive. Fining someone is could be, frankly, either way, depending on how you looked at it, whether it was punitive for the sake of punishing someone for not coming, as opposed to remedial in the use of that term, paying for costs of the non-appearance. And I said I'm not trying to hide the ball in any way. My thoughts are just upfront that the hard costs, if you will, not the inconvenience to the court, to our jurors, or to the parties, were incalculable in one sense. The jurors' time for those that showed up, and then it was about $40. It was $40 a head for the 13 we had to pay out that were sworn. That number comes over the $500 fine limit. But frankly, my thoughts up front are toward a contempt, toward one in civil nature, and toward reimbursement of the costs that were outlaid to those 13 jurors. That would be about $580 plus another, I think 520, frankly, if I do something, I'm likely to cap it at a $500 fine / reimbursement restitution. Those are my thoughts. They're definitely not set in stone, and circumstances can clearly change any part of my analysis. And I guess when I talked about civil versus criminal contempt and the consequences, I did some research, and the question is whether, a separate question is whether or not the contempt was in the presence of the court or outside the presence. In the presence of the court, the sitting judge has the authority to deal with the contempt. If it's outside the presence of the court, an affidavit needs to be filed and a separate judge needs to hear the matter. In my research, failing to appear is in the court immediate contempt that the court can deal with, as opposed to an affidavit filing for another court. Numerous cases talk about it in the context of attorneys not showing up for hearings, and that was deemed to be in the presence and under the jurisdiction or authority of that particular judge to handle. And that's the way, frankly, I'm viewing it. Though that attorney in the case wasn't immediately before the court, they were supposed to be, and in the court's presence they weren't there. I liken this to that. So that's my preliminary remarks in that regard. I am largely relying on my recollection from the hearing. I'm welcoming any information and testimony from either side to supplement it, any information if there's justification for non-appearance. So first thing I'd like to do is swear in Mr. Glennen and see if he would like to offer any supplemental information. Mr. Glennen, please raise your right hand. Do you swear or affirm under the penalty of perjury in the state of Nevada that the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
I do.
Okay. So that information I listed was from your sworn testimony at the last hearing, my recollection of it anyway, from the affidavit of the officer cleaning up the service document, proof of service, the motions, and any other information that was offered at the last hearing on November 8th. So anything you would like to correct or add to that?
I cannot tell you the words that were said to me by Mr. Plumo, but I had the distinct impression she was on her way to court. And I can't tell you what it was that he said that gave me that impression.
Everything else that I recited, is that accurate to the best of your knowledge?
Yes, Your Honor.
Anything else that you'd like to offer or supplement?
I think as Your Honor stated, a contempt is a crime against you as the sitting judge. And with that said, whatever Your Honor feels is fair is great, but all I'm worried about is, will she be at the next hearing?
No, I'll leave that alone. Mr. Pitaro, it's your office that was representing Ms. Blundo and engaging in some sort of communication off and on with Mr. Glennen. Would you like to offer any information, or have Ms. Blundo provide the court with any information?
If I may, thank you, Your Honor. Good afternoon. Just so we're clear, Mr. Fumo submitted the declaration which the court alluded to. I spoke with him concerning that, and he stands by that. He is in a jury trial right now, Your Honor, and that's why I'm making this appearance instead of him. So that's why he is not here. the court is correct in some of the facts that you said. What had happened is the week before, I had spoke with Mr. Glennen, and I was led to believe that Mr. Glennen was then going to call Mr. Fumo, because I was under the impression that an offer was out there waiting to determine whether it was going to be accepted back and forth, and Mr. Glennen would communicate with Mr. Fumo on that. On that day, I was supposed to be, believe it or not, up in Lincoln County on a preliminary hearing that did not go for various reasons while I was on my way up to Lincoln County. I turned around and came back. But nevertheless, Mr. Fumo reiterated me, as he put in there, that he tried to call Mr. Glennen and left some messages. It wasn't until the afternoon, I think it was the Monday afternoon that we're talking to. The real gist of this, of course, as far as the court is always concerned, is was this done in contumacious conduct towards the court or the system? And I can assure the court it was not. I can say that my involvement in the case leading up to it, as well as discussion with Mr. Fumo on this was one of the more confused misdemeanor cases I think I've ever been involved in, as to the back and forth, the ups and downs. But Mrs. Blundo did not in any way, shape, manner, or form attempt to insult the court by not appearing. My understanding is, in talking with her, she was as confused as everyone else was up until that call in the afternoon, and Mr. Fumo was unable to get in touch with her after that. So it's not that she was out there trying to insult the court or contempt to the court or anything of that nature. It was, quite truthfully, a very confused thing. And of course, the court is right. Well, you're served with it, you're served with it, and we don't dispute that. We're all lawyers. We know what that is. But in the nature of it, it was very confusing sort of situation. As to Mr. Glennon's point, I spoke with Ms. Blundo, and she assures the court, and she's authorized me to assure the court, that she will be in your courtroom at 8:30, I believe it is, Monday morning. There'll be no dispute as to that. She knows the consequences of not showing up, and that wasn't even part of the discussion. She said that she will be there and be ready to testify or whatever it is that the parties wish her to do, what the court wishes to do at that time. So with that, Your Honor, I mean, I understand the position the court obviously is always in a situation like this. This here was not conduct, it was flagrant, it was not meant to be, it was not meant to be insulting, it was confusion. And if the matter is set for Monday morning, she will in fact be here. Now, my understanding is she is in the courtroom now. She called me. I told her to go to the courtroom. She said she would. I can't see her through the video, but I'm assuming that if she wasn't there, I would have heard about it by now. So she is there, and the representations I'm making are that she will in fact be there on Monday morning. And when the court considers the penalty for the contempt, I wish the court to take into account the confused nature of this, and that it was not done with the intent to obstruct or interfere in any way with the process. And with that, unless the court has any questions you have of me, that's it. Now, as to, I don't know, I know what Mr. Fumo told me. He told Mr. Glennen, I can't speak for Mr. Glennen, thinking that meant she was on her way or not. Mr. Glennon's made his representations concerning his feelings. Mr. Fumo put in his statements there what it was. But once again, it was an interesting and muddled, if you will, process leading up to this matter. I listened to the portions of the, I guess it was the YouTube that was placed there and looked at it. So I have an idea of some of the arguments that were made to the court. If the court has any questions, I'd be more than happy to try to answer them to the best of my ability.
I guess the only question I have is whether or not you or Mr. Fumo told Ms. Blundo not to appear.
Your Honor, let me say this, absolutely not. I've been an attorney for about 50 years. Mr. Glennen used to work for me back in the day. We would never tell a client that. We would never tell a client not to appear at a court proceeding. That is not something that Mr. Fumo would do, I would do, or quite truthfully, the attorneys that we deal with on a daily basis. That is, it's just not something that happens, and I hope the court has never had the experience of an attorney having to admit telling someone not to show up, but that is not what happened here.
Okay, and frankly, the caveat to my question was not to attack or suggest that it was nefarious if there was a statement made, confusing process, and so that's why I asked it, because of the back and forth and the nature, if there was affirmative communications from either one of you for her not to, because of something that happened, as opposed, I'm clearly not trying to imply nefarious motives, so to speak. That was the vein in which I was asking the question, if that makes sense.
Yes, it does, Your Honor, and I appreciate it. I think what it was given the nature of the conversations, as I say, the last conversation I had with Mr. Glennen was the week before, and the message was he was going to call Mr. Fumo because to let us know what was happening. And my understanding and my belief is that Mr. Fumo called a couple times and they get a call back, and then got the call late that Monday afternoon. So it was the fact that everything was still up in the air until Mr. Glennon's call to Mr. Fumo late that afternoon is when things happened. And as Mr. Fumo stated, he was unable to contact or did not contact Ms. Blundo after that, Your Honor.
Okay, thank you. Ms. Armeni, you were obviously present at the hearing last time, have filed motions. Any comments regarding relevant issues to this that you'd like to address, of whether I misrepresented something, misunderstood something, or frankly, just as an officer of the court, any thoughts you might have?
I appreciate that, Your Honor, because I know I really don't have a place here today. I'm just listening. And obviously, we did file our motion to dismiss based on what occurred the day that our trial, or the last day our trial was set. I just think as far as the court, it appears, listening to Mr. Fumo and Mr. Glennen, everybody's miscommunicating everything. It doesn't appear that anybody had a clear understanding of what was going on. And I think to blame Melissa for that would not be fair. She is present now. She was present before, as the court noted. So it's not a witness that continually doesn't appear. So it lends its favor to, I think, the miscommunication of what was going on and the lack of communication by the state to pretrial or advise what was going on. If the court is going to take the position that Melissa should have to pay a civil contempt for the jury, I think the state is just as guilty and should be splitting that. Because we still don't know. I understand what the court said about earlier when we had our previous trial when you heard the motion to continue. And the position of the court was, which is the practice, nobody shows up at 8:30, but they do show up at 8:30 if they haven't been told to show up later in the day. So Mr. Glenn, the state knew at 8:30 that morning that Melissa was not there and chose to move forward with the trial and get those jurors impaneled. So to the extent that the court is going to put any blame on Ms. Blundo for not being there, and therefore the fee should be attributed to the jurors that wasted their time, I would submit the state submitted their time just as equally.
Okay, thank you. Mr. Glennen, any last thoughts from you?
Let's get this going. I'll submit it, Your Honor.
Okay, Ms. Blundo, I've essentially been engaging in some sort of a fact-finding process, trying to verify if my recollection is correct, see if I'm missing something, misinterpreting something. That's why I've been asking these questions of the attorneys. You're the one with potential sanctions right now. It's a stressful situation. I fully appreciate that. Your attorney, obviously for financial reasons, I'm assuming is appearing remotely. If there's anything that you would like to say, I'll swear you in like I did Mr. Glennen. I really didn't need to. Any of the attorneys or officers of the court, their lack of candor is something that's reported to the bar and taken very seriously. I'd swear you in, and you can tell me anything you'd like about this. You don't have to, so to speak, but you're welcome to. And based on anything that's happened or any thoughts that have come into your head to this point, if you would like to talk to Mr. Pitaro to make that decision or discuss anything you might want to say, happy to give you time. The Zoom hearings are awkward, so if you want to get on the phone with him, we can take a break, you can talk, and then we can come back in. Do you want to do that?
Please.
Okay. So we're going to take a brief break. Feel free to step out in the hallway so you've got some privacy. Mr. Pitaro, does your client have your number she can call you directly at, or do you need to call her?
She has the number, Your Honor.
Okay, so we'll await your return. Take all the time you need with Mr. Pitaro before you come back in. No rush, and I'm going to get up. The formal thing is to rise. Don't worry about it. I'm just going to wait your recall, everybody. Thank you. Good afternoon. Please be seated.
We are back on record with the State versus Leonardo Blundo, RCR 2023-124-588.
Okay. Ms. Blundo, after having consulted with Mr. Pitaro, anything you'd like to say? Yes? Okay, please raise your right hand. Do you swear or affirm under any perjury that the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
I do.
Okay, go ahead.
I just want to apologize to the court. There was no disrespect or purposeful not attending to the trial on the 8th. There's a lot of confusion around whether or not I was supposed to appear or not from my understanding. And I thought that maybe the case was being negotiated. It was obviously, as my attorney stated, a very confused mess, and I do apologize, but it was not on purpose. I appeared on August 24th when I was called, and I will be here on Monday.
Okay. I guess. No, we defer. I guess whatever you would like to offer or not, or is a little detail, but I guess what's key to me is the source of this confusion. I mean, I get it. The DA communicating through your attorneys, you've only been served paperwork, never been talked to personally by him, and then presumably the DA reached out to your attorneys, talked to you, doing their due diligence. You know, they're required to check in with victims. Have you changed your mind? What are your thoughts on negotiations? Clearly, it appears you didn't want any, or it to go, meaning you didn't want the case to go forward. But, and then there's no communication back to you one way or another. So there's a court order, essentially the subpoena show up, you have that background, and then not coming. I mean, presumably aware that attorneys and others are traveling up here. So I guess help me with the confusion.
I can do that. And I'm not wanting to point fingers or blame anyone. I'm not used to legal proceedings, and I'm only going based upon what I've dealt with this particular thing. On August 24th, when that trial was happening, I did not receive a phone call from anybody except for Mr. Glennen he was not communicating with my attorneys. My understanding was he was supposed to serve my attorneys as well as serving me, but I don't know because I'm not used to this stuff, so I'm not 100% sure. And I was not communicated with until 9:30 in the morning on the 24th, of the day of the trial then, that I was needed. And that was by Mr. Glennen calling me. Of course, I got dressed and went straight to the court and was there for that. So I was expecting a phone call from someone to tell me that I was needed based upon what happened on that date. The last communication I had with my attorney, and I have the voicemail on my phone, was on Tuesday, the day before, so the 7th, at 11:40 in the morning roughly, stating that he had tried to get a hold of Mr. Glennen. He had not heard anything. This was Mr. Fuma. He had not heard from Mr. Glennen, left a couple messages, nothing, no return phone calls back. For the moment, he was staying put, meaning Ozzy was staying put. He would contact me if he heard from Mr. Glennen, or if I heard from Mr. Glennen, because that tended to be what had happened on the 24th, to contact him. I never heard from anybody after that, so and it's wrong of me to make an assumption, but based upon what happened before on the 24th, my assumption was I was not needed here. Because I never heard from Mr. Glennen, the DA, or my attorney after 11:40 in the morning the day before.
And August 24th, you're referring to when they were trying to pick a jury and there was a down in Pahrump and there was a change of venue request?
Yes, Your Honor.
So the day before on the 7th, were you in Pahrump around?
I wasn't Pahrump.
Thank you. Mr. Pitaro, anything else on behalf of your client? And you're muted.
Thank you, Your Honor. Wait, let me do this to start the video again. No, Your Honor, I think we've covered. Once again, I don't think a penalty is necessarily ordered in this case under these circumstances. That's it. Melissa made a mistake, and it wasn't intentional. And I think the court, after listening to all these arguments that have been going on, can understand a bit of the confusion that was there. And once again, concerning her showing up Monday, she says, if she told you and she told me, she'll be there.
Okay, thank you.
Thank you.
Okay. The statutes covering this, like I said, Chapter 55 talks about not appearing pursuant to a subpoena as contemptuous, shall be punished as contempt. Doesn't define it beyond that, except in the civil arenas. So the fallback then is what is contempt, and that goes back to Chapter 22. 22010 says the following acts or omissions shall be deemed contempts, and subsection 4 says disobedience of a subpoena duly served. There's more to it, but the other portion is not relevant. Question is the disobedience of the subpoena being duly served. There's no dispute over the service, over the notice. The disobedience would be the not showing up, and whether the circumstances were so confusing as to justify the disobedience, essentially not showing up. Arguments, there's no doubt as to service, as to not showing up. The argument is this was confusing, it was not intentional, so even if there is contempt, the punishment should be withheld and or not imposed. Bottom line, the point has been made. There's a lot I would like to speculate on, and that is not appropriate. Here we have what appears to be a couple of still married individuals in a relationship, and because of the place of service, likely in business together, still knowing those are reasonable inferences, knowing in large part what is happening in each other's lives, subpoena being served, and an individual, Mr. Blundo, traveling north for a trial after failed negotiations. The confusing part, if you will, would be the deference, that's the best light I could place it in, that Mr. Glennen was giving the attorneys, Mr. Pitaro, Fumo, assisting Ms. Blundo. The lack of communication contributes definitely to a question as to what to do. Ms. Fumo is engaged, two of the most respected attorneys in southern Nevada. She's not been called off, they've not been called off. The order is to appear, and there was no appearance. The situation, despite many variables and potentials, like in anything that could happen at any moment in our lives with decisions, not that confusing, but it is definitely a mitigating factor. Frankly, I'll be finding contempt. I'll be required, according to the statute, to reduce this to writing. As far as the penalty, if any, I'm going to, frankly, Ms. Armeni's thoughts are somewhat persuasive. I understand from the state's perspective, trying to defer to Mr. Pitaro and Mr. Fumo to some degree, but the communication when we're talking about not your average misdemeanor trial in your own jurisdiction or at one close by, that communication contributed in some degree. So frankly, my decision will be for a fine under the statute, whether it's technically a fine or remedial measure for the juror fees. I'm going to cap it at the written maximum in the statute at $500. I'm going to withhold requirement of payment of $250, making sure she appears on Monday. That would have its own consequences in addition, but in order that $250 be paid. So it's basically in what we see in criminal orders or perhaps civil, a contempt finding of $500 with the penalty, 250 of that suspended and not imposed. That would be imposed in addition to any other violation for not coming next Monday. I have no reason to believe that I will need to impose the other 250, but the underlying 250 I'm going to impose. The situation is not that confusing, frustrating, no doubt, but not that confusing in the court's mind. I think this is a fair and appropriate remedy, and in light of the inconvenience to the courts, the parties, the jurors, all of them that showed up and took time off work, this is beyond fair in my mind. I'm sure parties have differing opinions on that, but so there'll be 500, 250 suspended. That 250 suspended will not be imposed if she shows up Monday, and the other 250 we'll ask, and I understand there's holidays and expenses in life coming up, that is to be paid to Reno Justice Court no later than January 31st. Gives plenty of time to work and allocate resources toward that. Is there any reason why and you couldn't come up with 250 by the 31st of January 2024?
No, you want-
Okay. We'll see you Monday, and then frankly, Monday morning, we'll be picking a jury in my mind. Well, we're going to be hearing arguments first. I asked the parties whether or not they wanted to have a hearing today or Monday, and my clerks informed me Monday regarding the motion to dismiss. So we'll handle that early Monday. That'll take a little bit of time. When we picked a jury and broke for lunch, we were back at 1 o'clock to start evidence. So if the case is going forward, if the motion to dismiss is not granted, I'm not a fan of wasting your time and having you sit down here in the lack of comfort. I'm perfectly fine with you showing up at 1 o'clock unless you're called off one way or the other. So if the motion to dismiss is not granted, is that satisfactory, 1 o'clock or 11 o'clock or whatever the parties would like? Ms. Armeni, is that okay with you?
Your Honor, in light of what transpired the last time we were in front of you, I think 1 o'clock seems appropriate.
Mr. Glennen, any problem with that?
No, that's great, Your Honor.
Mr. Pitaro, I assume that's okay?
Yes, Your Honor.
Okay, so be here no later than 1 o'clock unless you get a call from one of the attorneys, frankly, and or the court. I don't want there to be any issue with that. So when this hearing's over, I'll have you give your phone number to my clerk so we can notify you if it needs to be delayed or called off for whatever reason as well. I don't want there to be any miscommunication. As far as Monday morning and the parties wanting to argue it, I think we were set for 8 o'clock. So 8 o'clock for argument on the motion to dismiss. Still good for the parties, Mr. Glennen?
Yes, Your Honor.
Ms. Armeni?
Yes, Your Honor.
Okay, and I have received, just in case you wondered, I did receive the reply that was filed yesterday, read it yesterday. I'll research some of the cases already, and I welcome argument Monday morning. So thank you all for your time. I'll work on the order that I just issued, and we'll see you Monday for the motion and then trial if need be.
Judge, if I may clarify, just to confirm, all parties are expected to be in person on Monday.
Yeah, jury trial. Yep. Okay. All righty. Thank you. Have a good day.
All right, Your Honor.
Thank you.